Hello students. So welcome back. So we are on the day 10 of our series. So in the last class we discussed fundamental rights, right? So today we are going to continue that, and I hope by today's session we'll be finishing the fundamental rights. The outcomes that I am expecting from the sessions, I think that's being delivered to you, and I would love to know the comments, feedback on the comment box below. As well as I would love to inform you that I'm coming on an academy platform through the special classes. You just want to log in there and enjoy the classes. Every day 9 p.m. I'm coming with current affairs classes, daily current affairs classes, so please have a look on that also. So having further, we are now discussing the fundamental rights from 23 to 24, which talks about the right against exploitation. Now article 23 is talking two things. One is trafficking as well as forced labor. Now article 23 says human trafficking, unpaid forced labor and bonded labor. Trafficking means buying and selling of people. So this is very common, but there is an exception. These exemptions are where you have to actually look into with utmost carefulness. So the exception is that in case if a emergency situation comes, state can actually impose some compulsory service for the public purposes like military or some social services. State can have you on board. So this don't come under the article 23. Okay, that is an exemption. That is in very rare cases or extreme cases or in some emergency cases, up to the state for any military or social service. For example, if there is any flood or something, state can actually call your help. So that will not come under some unpaid forced labor or something. That is the exception. Now coming to article 24, which talks about the child labor. So here below 14 years, no child should be employed in any factory, mines or any hazardous activities. Here also there is one exemption, that is that if it is for some harmless or some innocent work, it is not prohibited. This is an area of debate, but right now it's not prohibited. So if any harmful job they are doing or in any factories or in any mines, this is prohibited under article 24. Now comes 25 to 28, that is freedom of religion. Our constitution gives some terms when it discussed about the freedom of religion. Article 25 is talking about the individual freedom. For example, what a single person can enjoy on behalf of this. For example, he can freely profess, he can practice, as well as he can propagate. For example, he can believe in something, he can practice that. For example, he can do some namaz or something, he can go to temple, as well as in a peaceful way, without the intention of conversion, he can propagate the religion also. Okay, so this is one, but again there are exceptions. These are restricted under public order, morality and health. For example, health matlab kya hai? For example, during COVID time, you must have heard that in Nizamuddin Dargah, there was some assemblies of some sect of Muslim community. So actually they said that this is an annual assembly that we have to have as part of our religion. This is part of our religious freedom, but it is not a religious freedom, because in the constitution itself it is said that yes, if it is something that is against the public order, or if it is against the morality, or if it is against the health, then it is going to have a different perspective on this. Then comes one said individual, then article 26 talks about collective freedom. So there are some religions will be there, right? So these religions have right to establish institutions, manage their own religious affairs, and if they have a property, they can administer them. So this is a collective religious freedom, whereas 25 gives individual freedom. Collective means as a religion, what right we are giving for the religion as such. They can establish institutions, they can manage religious affairs, as well as they can administer their property also. Okay, so 25th talked about individual freedom, 26 talks about the collective freedom. Now comes 27, freedom from taxation, which means that no person should be compelled by any religion to pay taxes. Be very clear here, to pay taxes. It is just talking about the taxes for the promotion of any particular religion. Why I am telling it, why I have underlined it here, even I have given in the red color also, I have highlighted in red color also. See, no tax should be collected, or no person is actually should be compelled to pay taxes for promotion of any religion, but there is an exemption. For example, a fee that is being charged for any kind of service, or for any kind of regulation, if any fee kind of thing is being collected, that is not coming under this freedom from tax action. So here only tax action is taken into consideration. Okay, so that is what article 27. So which means that 25 and 26 gives religious freedom, and 27 actually protect you from any kind of such encroachment or such kind of unwilling activity done by the religion also. So that is the beauty of our constitution. And then article 28 says about the religious instruction. Okay, in India, if a state is completely maintaining a religious institution or an instruction institution, that is completely prohibited. But at sometimes what happened, a trust based on the religion, they will actually establish it and state will administer it. Okay, that is permitted. State is not actually giving salary or something, state is administering it, but a trust under a religion established, that is permitted. Second category is that state recognized, aided, permitted on a voluntary basis. For example, some religious community may start an educational institution and later it may come as a aided college, you must have heard, that is permitted. Okay, only thing which is not permitted is that a state cannot come and start a institution for a specific religion which is completely owned by the religion, owned by the state. It is prohibited. Now article 29 and 30, cultural and educational right. Okay, now listen here. 29 says about all the sections, it's not just about the minorities. So be very careful in the statement when the examiner gives. There is a high chance that he will give article 29 talks about the conserving the art, tradition and culture of the minority communities. You may read it as right, but listen, article 29 is not talking only about the minority cultural right, but everyone, any section of citizens has the right to conserve their distinct language, script or the culture. Okay, and now 30 is about minority institutions. Okay, so this minority institutions exclusivity saying minority, so which is a right completely given for the religious and linguistic minority. We are giving this right to two kind of minorities, religious and linguistic minority. Okay, so there are other kind of minorities also. Okay, but we are not giving religious, either you should be religious or linguistic, then you will be having this particular right, that is establishing minority institutions. Okay, but in case if state is actually acquiring some property of this also comes under article 30, state must give proper compensation also. Okay, then comes article 32, which is very important, that is constitutional remedies. So constitutional remedies are called by Ambedkar as the soul and heart of the constitution. Okay, now both Supreme Court and High Court have this power, but remember under article 32 only Supreme Court comes. Okay, but when talking about the scope, the Supreme Court have a limited scope, but High Court have a wider scope. But High Court scope is not coming under article 32, it is coming under article 226. Why we are telling that Supreme Court is having narrower scope and High Court is having wider scope? For example, the Supreme Court can only deal the fundamental rights, but High Court, that is coming under 226, be very careful, under article 32 it only mentions Supreme Court, but in article 2026 when we talk about High Court, they can deal with fundamental rights also as well as legal rights also, but it is limited to that territory. Okay, but fundamental rights when come to Supreme Court, it is across the country, you can go and approach the Supreme Court under article 32. So this is the article. Now there are writs also given in the constitution, which means in any case if this fundamental rights are violated, you have 5 writs that can be filed in Supreme Court or the High Court to get your fundamental right done. So first one is habeas corpus. You must have heard it many times, to have the body, which means if a person is under any illegal detention, then court can say bring the body, that is habeas corpus. Second thing is mandamus, we command, mandamus we command, which means that we are telling a public official or a government servant to perform the duty. That is what mandamus, we command, you do it. Prohibition, Prohibition, certiorari, these two are related to judiciary. So prohibition means you are prohibiting. Prohibiting means a higher court, let's say high court, is stopping a lower court from exceeding its jurisdiction, which means that lower court is encroaching into the areas where high court should come in. So slowly they are going into, exceeding their jurisdiction into some other area where they are not supposed to have a word on it. Now, which is called a prohibition. So high court will say that stop. Okay, this is something preventive we call. Whereas certiorari means high court quashes the order of a lower court. High court came with the order. Sorry, so any lower court. So high court can say that what is this? Certiorari. It's quashed that order. Then quo warranto. For example, in an office, a person is being appointed by the government. You can ask on what authority you are sitting here. You can check the legality of that person to sit in that public office, his qualification, everything. Okay, and this quo warranto can be bought by any person. Habeas corpus, the person who is there in any detention, the other person can give. But Mandamus, prohibition, certiorari, there is a specific agent we are pointing out. But quo warranto, any person, it should not bother me like whether I am working in this office or I am working in that particular village where this office is there, nothing like that. Any interested person can give this writ quo warranto. By what authority you are sitting here? So habeas corpus, mandamus, prohibition, certiorari, quo warranto. In that, prohibition and certiorari is related with the judiciary. Now coming to the 33 and 35 articles, that is the last article. 33 means Parliament have the right to restrict these fundamental rights for any armed forces, police and intelligence agencies. 34 says about that if any martial law is in place, that says military law, then the fundamental right will be restricted. And only Parliament, this is important, no state legislature, only the Parliament has the power to make any laws to give effect to any fundamental rights like 16, 17, 23, ensure uniformity across India. That the right is only with the Parliament, not with the state legislature. So wherever I have highlighted with red color, you have to be very careful because that is the area where the question can be asked and it can be trapped. So by this we have come to the our fundamental rights session. I hope I took around below 1 hour in 2 sessions to complete this. And please listen this, take the note and attend more questions from Unacademy platforms. Also, you will get mock test and let's crack it together. And please do put your comments and your valuable feedback and what you feel about the sessions in the comment box. Thank you. Have a nice day. Let's crack it.